All right, members, it is about time we have attained the quorum. Item number 1, confirmation of minutes of the 26th meeting held on May the 24th. We have received no proposed amendments. Can I take the minutes as confirmed? Okay, then, matters arising, report on our meeting with the CS. The Director of Public Prosecution wrote to the PAC and about the PAC hearing. We have relayed members' concerns and comments. The CS said that the administration didn't have any intention of interfering with the LegCo's operation. However, she explained that the PAC hearing has to do with the criminal investigation of the former commissioner of ICAC. If criminal prosecution is undertaken, the SJ might be questioned as to whether any steps have been taken to minimize the impact. The letter by the DPP was meant to be a gentle reminder. The purpose is to make sure that both would be able to discharge their constitutional function without any prejudice to the criminal investigation. Ms. Emily Lau, is the CS of the view that the PAC hearing would get in the way of the criminal investigation and the potential prosecution? Well, as I said, the CS merely said that this is a gentle reminder to make sure that the criminal investigation will not be prejudiced. Mr. Ronnie Tong. Chairman, the DPP did ring me up to make the explanation. He was rather subtle in his explanation. We cannot see any situation that would interfere with the criminal investigation. As to whether the PAC hearing would have any impact on the prosecution, it has nothing to do with him. I don't think we should lump the two together. I think after the telephone conversation, we are aware of each other's position. On an informal occasion, I had a word with the SJ, and he also said that this is merely a gentle reminder. There is no intention of interfering with LegCo. Ms. Emily Lau, I hope that the administration doesn't have any evidence to prompt their letter. If we are irresponsible enough to do anything to interfere with them, then we would appreciate that. But we are all aware that we are discharging our respective duties. I think from this we understand that there is a mutual respect. If we have done something wrong, then fine. I'm not sure whether he mentioned anything that happened before that prompted this gentle reminder. I hope that going forward, the executive branch won't do anything like that. They don't have to do anything like that at all. Did you mention this, Chairman? The Vice Chairman can vouch for that. We have sufficiently ventilated our views. We don't really want to see this happen. When the administration understands that members' views have been reflected, well, if anything, they shouldn't get in the way of the work of the PAC. Well, I'm sure that the chairman of the PAC will not be under any influence, and their members as well. Any further questions? If not, business arising from previous council meetings, Legal Service Division report on subsidiary legislation gazetted on May the 24th and tabled in council on May the 29th. Legal advisor. Well, just a reminder that there are 22 pieces that have been submitted. Let's deal with them one by one. Legal advisor, please. Chairman, will members please refer to paper LS 56. Like the chair said, there is a total of 22 items of subsidiary legislation. There are 6 parts according to their natures. The first one has to do with the trade description ordinance. The first one is LN 72. This will come into effect on July the 19th. I'm sure members remember that the purpose of this piece is to broaden the scope of the ordinance, to prohibit specified unfair trade practices, and to introduce a civil compliance-based mechanism to enhance the effectiveness of the enforcement of the TDO. The executive branch has proceeded with a whole series of preparatory work. I'm going to mention the Communications Authority and the Customs and Excise Division of work, and that takes us to LN 71, that is the trade descriptions powers not exercisable by the Communications Authority notice. There may be certain overlapping in the enforcement powers, but here mainly we are dealing with the trade and services. Unless it has to do with the licensing, the CA would not be enforcing the law. That's the first part, Chairman. Well, let's deal with them batch by batch to see whether a subcommittee would be needed. All right, for this part, subcommittee. Okay, we don't see the need for a subcommittee. Let's move on to the next one. Legal advisor, please. Part 2, Chairman, signboard control system. Pages 3 and 4 cover all the relevant subsidiary legislation. The first one is Building Minor Works Regulation, commencement notice. September the 2nd will be the day these provisions will come into effect. And then LN 73, Building Minor Works Amendment Regulation 2013. Chairman, I don't propose to repeat all the enforcement details, except to say that the entire mechanism will come into effect on the 2nd of September this year. At the early part of this year, the development panel was briefed on the details. Members attending the meeting did raise a couple of concerns. All right, then, signboard control system. Do you see the need for a subcommittee? Mr. Wu Chi-wai. Well, members did express different opinions at the development panel. Now, we have encountered so many problems with regard to the windows inspection. I think it is justified to have a subcommittee. All right, who would like to join? Ms. Sid-ho, you take the floor to speak, or are you joining? Chairman, if I may come back to LN 71. All right, let's get this out of the way first, shall we? Right, shall we come back to that later on? Right, who would like to join this one? Okay, then. There will be a further circulation. Ms. Sid-ho would like to come back to the first batch. Beg your pardon, Chairman. Commencement date. There is no contention there, but I noticed that in one of the legal notices, it has to do with the enforcement power of the Customs and Excise, and there should be some discussion. I would propose a subcommittee. All right, Ms. Sid-ho proposed a subcommittee be formed for the first part. Any member wishing to join? Right, there will be further invitations. Part 3, legal advisor. Chairman, members are familiar with this. Under the new companies ordinance, this is the third batch of subsidiary legislation, LN 75 to 80. There are 2 points I'd like to highlight for members in particular. Previously, there were discussions about inspection of the director's personal information. This batch doesn't include the particular piece. 75 and 76. Previously, the SC and the HC did consider this. There were some amendments to be proposed for technical reason. They were put on the council's order paper, but we didn't get round to that during the amendment period. And the administration has decided to issue 2 new amendments to sort out the technical problems. So there are altogether 6 pieces here. I don't think I need to repeat all the minute details here, except to say that all the details are set out in the paper from paragraph 16 to 31. I get the feeling that members might wish to refer all these pieces to the subcommittee on new companies subsidiary legislation. On the 3rd of June, this will be put on the agenda. All right. This will be referred to Mr. Wong Ting Kwong's subcommittee for scrutiny. Next, Chairman, Part 4, and that's page 9 of the paper. Alignment of fees and charges for municipal services. Historically, we had the Urban Council and the Regional Council covering urban and new territories areas, and there were discrepancies in terms of the fees and charges between the 2 jurisdictions. In the 2013 policy address, the administration has proposed that the fees and charges will be aligned. So there are altogether 8 legal notices for this very purpose. The overriding principle is that if there are differences in pricing between the 2 places, then they would be aligned based on the lower of the 2 levels. For other specific fees and charges, like the peak hour and so on, there are some adjustments. All the details are set out in the paper, and the briefs made available to members. For recreational facilities, they will come into effect on the 1st of August. For others, licensing July the 19th. Thank you, Chairman. Subcommittee? Tommy Zhang. Mr. Tommy Zhang. Chairman. The alignment of fees and charges is a historical legacy from the municipal councils. The administration would like to have done this a long time ago. They would like to adjust them upwards, but nobody subscribed to this idea. The panel didn't support this proposition. Now we would support, I'm sure, that there is very little controversy among the members of different political persuasion that the fees will be aligned on the basis of the lower level. Now, from the legislative brief, there are 14 items that apply to urban and NT areas. That they were applied to one side of the equation, but they try to apply these to the NT and urban areas. At the moment, either part didn't have the fees and charges, but they just keep the fees and charges there anyway. I've read through the details. I don't have any strong views. I don't mind not having a subcommittee. I'm open to options.
Other members, any views? Ms. Emily Lau. Thank you, Tommy Zhang, for carefully reading the document. We're just considering whether anything is being omitted. If you have put it under a microscope and found that there is no omission, then of course there's no problem not having a subcommittee. But I want to make sure that Mr. Tommy Zhang has read it thoroughly. I don't see any omissions here. Like I said, there was a problem of fees being charged by one council only, and now, after standardization, both sides will have to pay the fees. So that's my point. Well, Chairman, I really don't understand why no people will be affected. What do you mean? I'm not suggesting that a subcommittee should be set up. I'm just asking your view. I can't explain to you exactly, but there are fees charged by either in the urban area or in the new territories. But now fees will be imposed on the facilities on both sides, both in urban area and in new territories. So it can't be called that no one will be affected. Well, that's the reason, because the service is not provided by one side. Though there are two sets of charging system. One is the FEHD, the other is municipal services. Mr. Wong Kok-heng. In fact, we followed up on this issue at the panel meeting. I agree that we don't need a subcommittee. Any other views? All right, so no subcommittee for this part. Next part, legal advisor, please. Part 5. Chairman, that's import and export related matters. The first one is LN 89. That's Import and Export Strategic Commodities Regulations Amendment of Schedule 1 Order 2013. Chairman, this amendment order is for the purpose of updating the list in Schedule 1, and we don't have anything to supplement. After it comes into operation, it is expected to come into operation on the 8th of July after the notice is published in the Gazette on the 5th. LN90. That's Import and Export General Regulations, Amendment of Schedule 7, Notice 2013. And that is so-called the scheme concerning the Kimberley Process Certification Scheme, and the Kingdom of Cambodia, the Republic of Kazakhstan, and the Republic of Panama will be added to the list of specified countries or places in Schedule 7 so that they will be eligible for processing rough diamonds and engaging in the trade in rough diamonds with these countries lawfully. Any views? No. Next part. Chairman, Part 6. These two notices are not related. The first one is one made under the Business Registration Ordinance. That is, the levy payable under the BRO will be lowered from 450 to 250 for for a 3-year levy. It will be reduced from 1,350 to 750. It will come into operation on the 19th of July 2013. The next notice is Road Traffic Breath Analyzing Instruments, Screening Devices and Pre-Screening Devices, Amendment Notice 2013. The purpose is to add the breath analyzing instrument manufactured by a German company in the law, so that the equipment can be used for conducting the breath analyzing test. It will come into operation on the 19th of July. So much for my report, Mr. Ho. Yes, Chairman, in relation to the Business Registration Ordinance and the Protection Against Insolvency Fund, the Labour Party would like to set up a subcommittee. All right. Does any member wish to join? All right, invitations were circulated. Road Traffic Ordinance, do we need a subcommittee? All right. May I remind members that the deadline for amending these items of subsidiary legislation is 26th of June or 17th of July if extended by a resolution of the Council. Now, next item. Further business for the Council meeting of the 5th of June 2013. report number 18/1213 of the House Committee on consideration of subsidiary legislation and other instruments. It covers 8 items of subsidiary legislation, the period for amendment of which will expire on the 5th of June, and we have not received any indication from members in relation to their intention to speak on the subsidiary legislation. Questions? Mr. James Tin and I have replaced the oral questions. And Ms. Sid Ho, about reports of Bills Committee and subcommittees, please report on the BC on education amendment bills. We had 2 meetings. We also invited deputations to express their views. Members support the amendment so that for the Grant Schools Provident Fund and Subsidized Schools Provident Fund, in the case of teachers going bankrupt, the retirement, the fund under these 2 funds will be protected or excluded from his property upon bankruptcy. We are not going to move any amendment. On the 19th of June, the second reading will be resumed. I remind members that should you want to move an amendment, the deadline is the 8th of June. Report of the Committee on Poverty on Setting the Poverty Line, Mr. K.K. Fong. The relevant, the setting of the poverty line has been tasked to the Commission on Poverty, and the Subcommittee on Poverty had meetings with the administration, deputations, and we have come up with 5 recommendations as set out in paragraph 29. We agree that after discussion at this House Committee meeting, the report will be given to the COP for their response and consideration. I ask members to note this report. The report will be forwarded to the COP for consideration and response. Position on bills committees and subcommittees. As at the 30th of May, Thursday, there are 15 bills committees, 7 subcommittees under HC, and 7 subcommittees on policy issues on the panels in action, and 3 subcommittees are on the waiting list. Next item, request of Kwan-yuen for a debate slot at the council meeting of the 5th of June 2013 to move a motion on vote of no confidence in the President of the Legislative Council. Mr. Kwan-yuen, 3 minutes. Thank you, Chairman. Well, originally, I am minded to protest against the President of this Council, Mr. Jasper Zhang, in 2 phases, because time and again he abused his powers to stop members from speaking, which is in breach of the rules of procedure, and in relation to the freedom of speech in the Council and the powers of legislators, this has constituted a great insult. On the other hand, some also view this as passing favoritism towards the administration so that the appropriation bill can be passed very quickly. Well, if this is done, then in the future there is no need to move any amendments to the appropriation bill because it must be passed anyway. So in handling the motion debate on the appropriation bill, the President of the Legislative Council abused his powers. He also relied on Article 72(1) of the Basic Law, saying that he had to do so in order to preside over the meeting. So I am going to move adjournment debate. I was going to do so, and that no government official would attend, and it won't be approved by the President, and the House Committee wouldn't accept it. Well, I could have waited for my slot for motion. Well, I moved the motion this year already, so there's no chance for me to do so. If I had to wait till October, November, or even next year in January or February, then that would become something of the past. So I would like to move this forward or have a discussion today. This is our right. We can vote, cast a vote of no confidence in the President. I hope members can discuss this issue, and if possible, I hope that at the meeting in June, that's the next meeting held on the 5th of June, the motion can be moved at the Council. Mr. Leung Yiu-chung, 2 minutes. We support Mr. Wong Yok-man in moving this motion. The reason is that we think that there is abuse of power on the part of the President, and he has been unfair. He told us beforehand that the meeting must be adjourned in the evening of the 22nd of May. He didn't tell us why the meeting had to be adjourned at that specific time, except for the fact that the administration said that the bill must be passed on the 23rd. And he had no idea of the content of members' speeches. So why had he insisted on adjourning the meeting on the 22nd? If he found the members' speech was repetitious, so on and so forth, I could understand that. But I really don't have any idea why he had to set the time limit. And the President also said in the public that he would allow members to speak if they wish to do so, unless the member was irrelevant or repetitious. So I think that he was unfair, and I support Mr. Wong Yok-man's motion. Mr. Albert Ho. Chairman, well, let's not consider for a moment whether we support this motion or not. Let's look at the nature of this motion. It has to do with whether we have confidence in the President. We all understand that the President's duty is to preside over meetings, and if he has lost the confidence of members, he should step down as soon as possible so that someone with the confidence of the majority of members in the Council can take over his work. Well, just like what I have been saying in the past, that's the spirit. Of course, well, we do not have anything on the agenda that can allow us to vote on whether the President should be dismissed or relieved of his duties or not. We're asking for a debate slot for discussing this issue. It is important that the President has our trust and confidence. And I think that this motion should be given priority in terms of debate and voting. So, under this principle, whether you are for or against this motion, you should support giving priority to this motion so that it can be dealt with at the Council sooner. Ms. Claudia Mo. I support Mr. Raymond Wong's request. Firstly, I think Jasper Zhang, as president of the LegCo, pretended to be democratic, pretended to have a consultation. He was really shameless when he cut the filibuster short. And also, I think the motion should be allowed to be debated first. Otherwise, there is no chance for this motion to be moved again within this session.
Chairman, I agree with what member said. It's not as if one or two members are unhappy or expressing no confidence in the President. There are many members who expressed no confidence. Now, this is a no confidence vote. Has Zhang Yuxing committed any offense? It all depends on the results of the judicial review. He is presiding over the meeting under BL 72(1), and this is dangerous. I think this is even more dangerous than Article ROP 92. Now, even if he has the power, whether he is exercising his power properly, this can be subject to debate. Now, this 7-page and 19-paragraph ruling handed down by the President has been handled really poorly. On the 13th of May, he decided to cut short the debate. 1:30, May the 14th, he ended it all. Now, this ruling was issued on May the 16th, and members didn't have any opportunity to express their lack of confidence or the dissatisfaction or raised anything for debate. I think it's a good idea for us to move a no-confidence debate. Members who oppose our views can express their views during that debate. I mean, if you say that we're trumping up the charges, then you can speak up, and this is the best way forward. Mr. Wong Kwa-hing, Chairman, I'm really glad that Mr. Raymond Wong is moving this no-confidence motion, but I don't think you should be happy prematurely. I'm happy because Mr. Raymond Wong and other members resorted to filibustering, wasting a total of 15 days of electoral time. Let's take $2.5 million per day. He's wasted close to $40 million, not to mention interfering with the normal proceedings and the normal workings of the Legislative Council. He's putting forward this no-confidence motion. I think it precisely shows how correct Mr. Zhang Yuxing was as a president. He was acting reasonably, sensibly, and lawfully. While I'm happy with this motion, but I don't think I can support this motion. If anything, I'm in opposition to this motion, so I don't think I will be in a position to support the idea of setting aside time for us to vote, cast a no-confidence vote on the President. Mr. Ho, Chairman, I support the idea of having the no-confidence motion as soon as possible, because we have to air our views in this regard. That Osaka mayor uttered a remark about the comfort women, and there was a vote within a fortnight's time. The cutting short the debate is something that is really unusual. It is not a daily occurrence. We haven't got any established procedure for this to happen. The smooth functioning of the council includes members' right to speak, the room to express themselves. So I think anybody here who is for or against this idea should engage in a debate, and we should discuss how best we can take this going forward. Mr. Kenneth Leung, I am in favor of this. Mr. Wong Kwa-hing bandied about a figure of $2.5 million per day and $40 million in total. Now, you're not saving anything in absence of filibustering. I think if you want to count the cost, you should work out the opportunity cost. I mean, if you lost $1 billion in opportunity cost, then that's what you should include. Ms. Leung, Priscilla Leung. Chairman, I think instead of having a no-confidence motion, we should look at the rules of procedure. 3 years ago, we had bananas thrown in the council, and we started talking about amending the rules of procedure. We should give the president some more guidelines, but the Democrats objected to this idea. The ROP, Mr. Leung Kwa-hong, filed for a judicial review. It was clear from the court that the president is presiding over the meeting. He has to maintain order in the council. If there are ambiguities in the law, the president can exercise his discretion in order to ensure smooth functioning of the council. So in the court, this has been made very clear. I think the only thing we should debate is whether we should make the rules of procedure more specific. that we have different views. You may argue that the President cut short the debate too abruptly. We feel that he has allowed the debate to go on for too long. He shouldn't have left it for so long before doing so. I think at the end of the day, the rules of procedure has the rules for the referee, and he is acting in a sensible and constitutional manner. Now, you may say that you want to have the filibustering that they can go on ad infinitum. I think at the end of the day, it's not a question of moving a no-confidence motion and be able to resolve the problem. I think the thing is to how to amend the rules of procedure and put things beyond doubt. So I don't think I can support this no-confidence motion. Mr. Ip Kwan-yuen. Chairman, some accused the President of abusing power and acting unfairly. We have 36 members who jointly petitioned the President to cut short the debate. The parties said that they would support the decision. Has there been a case of abuse of power? Has there been any unfairness? I'm sure that this is playing for the members of the public. Now you're putting forward this no confidence motion against the President of the Council. I think this is the power of individual members. We won't get in the way. Now, there is no problem if you act in accordance with the rules of procedure. Now, what you are asking for is to seek another time slot for this to be done. Then the DAB will object to that. Now, you have been arguing forcefully for this to happen. Then I think you should move this on behalf of Mr. Raymond Wong. You don't have to just indicate your support that you have your own time slot. You're not really lending a helping hand to Raymond Wong. And you are saying that you're supportive of this idea. I mean, I'm mystified as to what you have in mind. The DAB is objecting to this in no uncertain terms. Everyone is queuing up for the debate slot. I think if you want to do it, you have to queue up for your own time slot for debates. We welcome a debate here. We have to let the public know what this is all about. That we can have the arguments go ahead and conduct it so that we can let the public know what it is all about. Mr. Ng Sing, well, let me chip in here. We talked about costs. For the members of the public, we are wasting taxpayers' money, and we're not really achieving what we are supposed to achieve. I think this is something that we have to learn from. How many bills have we passed? How many initiatives have we endorsed? How much funding have we dispersed for the posts to be created, and so on. Now, if we yell all day and fail to achieve anything, that there would be a lose-lose situation. I don't think you can say that all members of the public would be against filibustering or would be all in support of filibustering. There is no one single voice. I think the President has handed down the ruling in writing, which is sufficiently insufficient detail. I think we have to give the benefit of the doubt to the President. It is not a good idea for us to waste any more taxpayers' money or any time here. As members, we should take the lead to flout the ROP. If there are members who would like to yield the floor, then fine. I mean, the key thing is that we should not violate the rules of procedure. Mr. James Dean. Chairman, as far as filibustering as a means to deal with members' aspirations, the Liberal Party has always been in opposition. when I ran for office in NT East, and Miriam Lau also running for office, we distributed a lot of flyers in opposition of filibustering. So we never took part in this. As regards the President's ruling, Mr. Kwok Him's has already made the point that the President has the power. He has the obligation to handle the filibustering, so we didn't sign the petition. Now, once the President has cut short the debate, the Liberal Party expressed our support. Now, we are opposed to filibustering. We support cutting short the filibustering. Some may argue that this is too late. Some said that this is too soon. As far as the Liberal Party is concerned, we should not allow these kind of filibustering to have gone on for so long in the first place. Mr. Paul Chairman, it's not a question of whether we support the decision of the President regarding the filibustering. We're not. It's not a question of whether we support the no confidence motion. Under ROP 13A, should we allow a slot for debate? So it's not a question of whether we support it or not. Under ROP 13A, it is made very clear that except for the exceptions in 13B, now we have JA for removing members and so on. Now this motion, I don't think it falls within 13B, so we have to go back to 13A. Now for 13A, do we, as a House committee, make the recommendation? I think this is something that can be discussed. I agree with Mr. Albert Ho that it is important for us to have to take a view regarding the President's decision. So we should have a debate. There is no reason why we should stall the matter, or whether we should stop it from happening. So from this reason, I would support this motion. Mr. Michael Tin, Chairman, I don't think President Zhang made the wrong decision, so I wouldn't support this no confidence motion. I feel that for you to say that this is urgent enough, so much so that we have to have a slot for debate, I don't think I can support this idea. Let me say a little bit about how I see filibustering. Filibustering does have its value in a democratic system because it will ensure that the minority voices will be heard. But I think this has to be predicated on three principles. First of all, we must have a groundswell of support from the public. Second, there must be a mechanism for stopping the filibustering. Third, filibustering will grind everything to a halt. Now, with regard to this budget, if this is on a minority decision, then it would be hijacking the issue. I haven't heard anyone in the street supporting cutting the government budget to zero. Indefinite filibustering is unreasonable. I think by filibustering, you're trying to make the government withdraw the budget. There is no room to withdraw the budget. I think you are playing a game here. And I don't think anybody would like to see Hong Kong grind to a halt in terms of public services. But in overseas jurisdictions, they do have the closure mechanism. They have the time limit on the speaking time. In Hong Kong, we don't have anything like that. And sooner or later, the President has to cut short the debate. It's a matter of when. Now, we have been stalling the matter for so long. We've heard what we wanted to hear. And there was nothing new being uttered after some time. So I don't think I can support this idea.
Yeah.
Does any other member wish to speak? Mr. Albert Chan. Chairman, well, of course, there are different ways to discuss the motion moved by a member at the House Committee's meeting. Well, it's the motion moved by Mr. Wong Yok Man. It's actually a procedural debate. that's because we do not have the relevant arrangement. And for procedural motions or procedural debate, it overrides other forms of debate. So it is a very important motion, and whether you are supporting it or not, a chance should be given for members to state their positions. And the voting is also important as well. The voting result has an impact on the issue. Well, there are members in this council, at least 4 of us, who have doubts about the fairness of the president's conduct, and if this doubt is not addressed, then it will linger on, and some members in this council will remain doubtful whether the president is fair or not. This doubt will just linger on. However, if you allow the motion to go ahead and put this to a vote, the voting result will show whether the majority of the council supports the president's ruling. So if you disallow Mr. Wang Yukman's motion to go ahead, you're actually helping us so that we will continue to have this doubt in the mind that the president is not reasonable, is not being fair, and he has abused his power. Now, I want to remind members that what we're discussing is whether we can, by invoking ROP Rule 13A, allow Mr. Wang Yukman to move his motion, and a priority be accorded to his motion to go first. If you have a debate slot, you can move the motion any time. And if necessary, this matter can go back to CROP for discussion. Dr. Kenneth Chan, Chairman. Now, I support this motion to be debated at the council meeting. Now, just a point of information. When some members suggested using filibustering to stall the passing of the appropriation bill, at first the president said that no joint debate could be conducted. They must be debated on and voted on one by one. But it seems that the goalposts were being moved as it went along, and I think that the president might have made a number of errors in his judgment in the process, so that the expectations of members had not been met, and that is very important. I think that as far as the council business is concerned, this motion should be dealt with as soon as possible so as to prevent further impact on our work in the future. So we ask for a reasonable and rational discussion, and I think the matter should be clarified as soon as possible. My judgment is that in the process, on a number of occasions, because of the president's ruling, my expectations were not met. Does any other member wish to speak? Mr. Leung Kwok-hong. Chairman, Mr. Ng Leung Sing and Mr. Wang Kwok-hing both said that our filibuster actually got in their way. But what have you actually done in this council? All these motions are non-binding. So what actually have you done? Article 74, the Legislative Council of this council, and the member may introduce bills in accordance with the provisions of this law and legal procedures. Bills which do not relate to public expenditure, political structure, or the operation of the government may be introduced individually or jointly by members of the council. The written consent of the chief executive shall be required before bills relating to government policies are introduced. That is, for motions that are binding, you need the consent of the government. So what have you done? There was a case involving myself and Rita Fan, and I lost hundreds of thousands of dollars. Yes, I took the case to the court. And what have the two of you done for the interest of Hong Kong? Now, Link Reid, well, that didn't involve the two of you. And putting a cap on the PRH rent, well, you took part in the voting procedure and the other matter as well. For the motions carried, I think you should apologize to the members of the public. That's we're spending $2.5 million a day for you to help the government, to be rubber stamps of the government. $2.55 million a day. Is it enough? And on Friday you will be treated feast. Dr. Lo Wai-kwok. I think Chairman has already made it clear that we are talking about whether a debate slot should be allocated to the next council meeting. We should not continue to argue whether the filibuster should be cut short or not. I think as a member who took part throughout the filibustering exercise, I also needed to speak out. When Jasper Zhang, our president, made arrangements for the 700+ amendments, for those taken part in the meetings, we all understand that he had been very careful in what amendments could be combined under one joint debate or not. And for the time limit and the voting procedure, there have been discussions and ample time have been given for members to address the council. And it's true that council meetings cost money, and that is why we need to make good use of the public money. So, Chairman, I don't agree with what was said. As for an extra debate slot being allocated to the next meeting, I don't agree because we have waited so much time. We had a lot of catching up to do. We need more time for meetings of panels and subcommittees, etc. So I don't agree with this idea. Dr. N. Chang. Now, Mr. Wong Yok Man would like to move a motion on vote of no confidence in the president of LegCo, basically because in May, on the 17th of May, well, the president abused his power to stop members from speaking, and he was being very unfair in presiding over the meeting. He was giving favoritism towards the government. I think members of the public watching this meeting in front of the TV would understand very well that the filibustering went on for over 10 days, and the president of the Legislative Council had given sufficient time for members to speak. If you said the time wasn't enough, then how much more would you need? Mr. Jasper Zhang, the president, invoked Basic Law Article 72(1) to preside over the meeting in accordance with the powers conferred to the president, and he acted in accordance with the rules of procedure. And he also relied on Rule 92 of the Rules of Procedure. For matters not stipulated in the Rules of Procedure, the President of the Legislative Council could make decisions. So how can you say that Mr. Zhang had abused his power as President? For other matters like how this filibuster could come to an end. President indeed consulted members. However, we failed to come up with a concrete suggestion to the President. That's why we do not support this proposal. 1 minute, Mr. Lang Kwok-hong. Chairman, first of all, on the 14th of June, Mr. Jasper Zhang WhatsApped me, asked me when the JR would take place. I said they're not decided yet. I have no money, so you're forcing me to go ahead. I really need to go back and consider seriously whether I should go ahead. Having heard what members from the pro-establishment camp said, I really need to consider this seriously. The judge was very inappropriate. He says in his judgment that he will not interfere with the operation of the Legislative Council, but he went on in his judgment to pass remarks about the Council. Now, I exercise my rights in initiating this court case if I don't need to pay any costs, and of course I will go ahead with the JR. So I am seriously considering launching a JR. Does any other member wish to speak? If not, I will allow Mr. Wong to respond. 2 minutes. Well, like I said, it's just a time for us to discuss this matter. With just like Mr. Albert Ho, Mr. Paul Chair, they were very succinct. They as well, they talked about the roots of this matter as well. Others, well, you don't, just like Dr. Ann Chang, you don't really know what you're talking about. So you can save it for the debate and you can defend Mr. Jasper Zhang. You're being irrelevant. The other is Dr. Priscilla Leung, and she's teaching in the university and she talks about the rules of procedure. Dr. Lo Wai Kwok, well, he's always using the straw man fallacy. So I just put forward this proposal. I'm asking for permission for me to jump the queue. If you don't allow me to do so, let's put this to a vote. So there are audience in front of TV camera. Show them that we are of quality. Don't you should not become rubbish. If you really want to talk, you talk to your husband at home. What you've said is totally irrelevant. You talked about a vote of no confidence. Well, you could do that during the debate, motion debate, and you can say whatever you want during the debate in defense of President. My request is clear. I'm asking for a slot for me to move this motion sooner. If you don't allow me to move this motion sooner, I will eventually move this motion anyway. And you still have room during the motion debate to air your views and cast your vote. So please, at least let's have some quality here. I won't resort to rough battle here. I'm being very civilized. About the next agenda item, I will rebut you, Dr. Ann Chang. You know nothing about the law. I now put this to a vote. Will those in favor of Mr. Wong Yok Man's request for a debate slot at the Council meeting on the 5th of June 2013 to move a motion on vote of no confidence in the President of the Legislative Council, please raise your hand. Mr. Wong Yok Man claims a division. The bell will ring for 5 minutes.
同事請肅靜啊，唔好喺度罵戰。梁國雄議員、蔣麗芸議員，若果你要辯論嘅，可以另擇地方。其實呢啲咁嘅議事規則做翻剪報啊13B，唔係你咪丟個13B咯，對咯，係嘛？冇問題，冇問題啊，丟個13B咯。咁但係你要議事規則傾點㗎啦，咁一個 package 傾咗幾樣嘢咯，即係頭先我講，你係將budget嗰度分開處理咯，有限時咯。你規定佢點剪報，即係好過人去點剪報，其他議案咪唔好剪咯，係咪？其他議案嘅講到咁上下，叫政府收翻就算。
notice， 你有 point of order 可以 make submission 等你 consider 嘅。咁當然間我又唔排除。係啊，其實但係會唔係都算。我哋立法會講法律㗎。我哋冇講。
現在開始投票。
Please proceed to vote.
喺我宣布停。
Before voting ends, please check your votes. If there are no questions, voting now ends. Please display the results. 58 present, 23 for, 34 against. So the motion is negatived. The next one is a proposal of Dr. Honorable N. Cheung for Chairman of the House to move motions under Rule 49. B1 of the ROP to relieve Mr. Wang Yukman and Mr. Albert Chen of their duties as members of the Council. Ms. N. Cheung. With some try to threaten me, but I think as councillor we have to discharge our duty and we have to act in accordance with the ROP and the Basic Law. Mr. Raymond Wong and Mr. Albert Chan on the 21st of May 2013 was convicted of unlawful assembly at the Eastern Magistracy and was sentenced to 5 weeks and 6 weeks under 79(6) of the Basic Law. The legal members, if they are convicted and sentenced to imprisonment for 1 month or more for a criminal offence committed within or outside Hong Kong, then he will be relieved of his duty by a motion passed by 2/3 of the members present, and the member will be disqualified for the office. This is a matter that has aroused public concerns. There were 2 cases of eligible members being sentenced to a 1-month sentence, and under 79(6) of the Basic Law and 49B1 of the ROP can be invoked to move a motion to relieve them of the duties. In accordance with the practice of the Council, I hope that on the 31st of May we can have some discussion at the House Committee, that is today. I propose that the Chairman of the House Committee would move the motion to relieve them of the duties under the Basic Law, 79(6) of the Basic Law and 49B1 of the ROP. A motion be moved to relieve Mr. Raymond Wong and Mr. Albert Chan's duty as legal members. Well, this is very straightforward. Basically, I'm requested to, as Chairman of the House Committee, move this particular motion on behalf of the Council. Failing that, any member can so move at the Council meeting, provided that prior notice is given. So it's not a question of whether I will be moving the motion on behalf of you. Right, then I give the floor to Mr. Raymond Wong and Mr. Albert Chan, 3 minutes each. Before I throw the floor open for members, 2 minutes for other members each. Mr. Raymond Wong. Chairman, I've got a paper tabled in front of members, so I will be trying to look at this from the legal point of view. Now, everybody under 79(6) of the Basic Law, anybody can move this motion. Now, our situation is somewhat different from others. We can invoke other pieces of legislation. This is open to debate. I may seek a judicial review. I've chatted with the legal advisor of the Council. It is impossible for me to get in all the details within 3 minutes. I've got a paper, and I hope that Dr. N. Chung would have a look at this paper. I think as a councillor here, we cannot skive off our duties. We have to read the papers and understand the situation. I won't get entangled in an emotional debate like this. Now, in my paper, a response to Dr. N. Chung, there are a couple of points I'd like to highlight. First of all, under the Criminal Procedures Ordinance, there is mention of suspended sentence. In Annex 3, there are exceptions listed there. Second, in the relevant provisions, suspend the sentence. How is it different from actual imprisonment? And there is an exemption regarding disqualification from office. Now, some said that the Basic Law is or has an overriding effect. Now you are invoking Basic Law 79(6), and this is overriding other legislation. I beg to differ, because we are moving this on the basis of the suspended sentence. the magistrate handed down the sentence on 109, section 109. Now, the office, as far as we understand, the office cannot be stripped off. There is such an exemption there in the legislation. So I think that this is something that we should look into. The other thing which is just as important is under the Criminal Procedures Ordinance 109C, during the suspended sentence period, if someone commits an offense, there would be 4 scenarios. Simply put, now on the 1st of July, if I were to be convicted of unlawful assembly, then I will have to serve the 6 weeks. For the other sentences, they would go on concurrently. And then you would be triggering a mechanism to relieve me of the duty. That would be in accordance with Section 109 and Basic Law 1796. Now, if you fail to do this for the first time, then you'll be doing this for the second time. Now, this is debatable under the law. I hope that Jimmy will have a look at this as well. I've had a word with the lawyers myself. Now, you're trying to relieve us of the duties. We have so many senior counsels here. I'm sure that the president and the legal advisor have read this. There are some debatable points. This 8-page submission is exhaustive. I haven't got time to get in all the details here. Mr. Albert Chan. Well, we are always having in mind this prospect of having our office being stripped. Now, we may be filing for an appeal against the seriousness of the offense. We will be filing an appeal against the sentencing. We're getting all the documentation ready. Dr. N. Chang is so bold to activate this mechanism to relieve us of the duties. I hope that she would succeed. I think that we can run for office again, and then this would be equivalent to a de facto referendum. In 2010, the result of the referendum shows that for the 5 districts, if you look at the proportion and the pattern, they are quite similar. If we can have this referendum in anti-Western Kowloon West, then we don't have to resign. We can run for office all over again. Now, we are grateful to DAB for moving this motion, and we will not be accused of wasting taxpayers' money. I'm sure that given the current political climate, the referendum will take place by October, by September. I hope that C.Y. Leung would have stepped down at the time, and are we going to have universal suffrage at a certain time? This is definitely going to be a subject for fighting for downing the Hong Kong Communist administration and for pursuing universal suffrage. It doesn't matter if I serve the council 1 or 2 years less, as long as we can get on this movement to arouse the members of the public. You're giving us 6 months for mobilization. You're giving us 6 months to mobilize the people to join this movement. I welcome that, Dr. N. Zhang.
Ms. Claudia Mo. Chairman, in this case, Mr. Albert Chan and Mr. Raymond Wong did not have any personal gain, and secondly, they face a suspended sentence instead of immediate imprisonment. So we don't need a lawyer to tell us how severe the penalty is. And it's because of the political act on their part that they were sentenced by the court, so I'm against this motion. Mr. Michael Tien. Chairman, will never occur to me that one day I would really agree with Ms. Claudia Mo's views. I need to declare, first of all, that I don't agree with the conduct of the two members in blatantly challenging the law. According to Basic Law Article 79, there are 7 circumstances under which a legislative council member may be relieved of his or her duties. And we're talking about Rule 6 here. As for the first 5 conditions, the duties would automatically, the member would automatically be relieved of his duties. For number 6, however, it's up to members to decide by way of voting whether the member should be relieved of his or her duties. As whether the motion should be moved by an individual member or by the House Committee Chairman on the member's behalf. Well, there are considerations, first on the seriousness and the circumstances of the case as said by Ms. Claudia Mo just now. In terms of severity of the offences they were charged with and convicted of, unlawful assembly and other offences. I may not subscribe to their views, but I agree that they did not do it for personal gain. It's very different from Mr. Chin Pui-chung's case in relation to using false instruments. And suspended sentence was passed instead of immediate imprisonment. So it shows that it's not very serious and no casualty was involved in this incident. So I hope that next time they'll be more careful. Dr. Helena Wong. I agree with Ms. Claudia Mo and Mr. Michael Tien's. We need to consider the nature of the offense and the seriousness of the offense. The Democratic Party does not support this motion that the chairman of the House Committee should move this motion to relieve them of their duties. The Democratic Party is very concerned whether more oppression would be imposed on participants of social movements. We're seeing more and more such participants being prosecuted. Are we moving towards an era of white terror so that through arrests and prosecutions and motions to relieve members of their duties, you can silence members and members in this council and the public? Now, they have been sentenced by the court. They must face their liability. As for whether members should exercise our obligations to relieve members of their duties in this council, I think we need to be careful. Now, having considered all the factors mentioned, for members returned by direct elections, they are backed by 20 or 30,000 voters at least. They have much more mandate than Mr. C.Y. Leung. If they are to be relieved of his or her their duties, the power should be given to voters so that in the next election they can decide whether to elect them or not. Mr. Ronnie Tong. Well, I originally didn't want to speak, but I have to respond. In fact, this motion is similar to the previous one, is of a technical nature. The last motion was about letting the member jump the queue. For this one, well, I think this motion is not really necessary, and you may consider this when you vote. As for the point of law raised by Mr. Raymond Wong, the decision to relieve members of their duties is definitely a political decision. It's not the logical one, let alone any consideration of the law. So the basic law says, only talks about the sentence. There is no mentioning of how the sentence should be executed. The suspended sentence means no sentence at all. From the point of law, a suspended sentence is still a sentence. So I think Mr. Raymond Wong's argument should be based on his conduct in this incident rather than from basing on the points of law. Mr. Chen Ji-chun. Well, about this motion to relieve members of their duties, even if Dr. N. Chang hasn't moved this motion, Mr. Paul Chair will move a motion anyway. So as Mr. Ronnie Tong said, that you just need to move the motion, you don't need to explain it. Dr. N. Chang says that this motion can be moved in accordance with Basic Laws, Article 79, etc. And we had precedents. And last time, Mr. Paul Chair moved this motion based on the provision, and in the end, he voted against the motion. And last time, Mr. Paul Chan, Chen Kim-po, and Raymond Tam, Samson Tam, voted against the motion. So she didn't just initiate the procedure. Well, Ms. Ann Chang, if you want to praise the CPG, you just go ahead and do what you want. You can have your own performance. Ms. Sit-ho. The public ordinance was a piece of legislation for political oppression in the past. And what the two members did was a political act that night. So according to Mr. Martin Lee, when the Basic Law was drafted, it was anticipated that such incidents would occur. There would be political prosecutions. And that is why the motion would only be passed with 2/3 majority of the members. And if it's a political act, it should be up to voters to decide whether these members should be relieved of their duties at the next election. And in 2012, voters already indicated that they supported these two members back in this council to continue to fight for them and to have political assemblies. And that although we may not subscribe to their views, we should respect the voting result. We should respect the decision of voters, and we therefore are against this motion. Mr. James Tan. Chairman. Well, Dr. N. Chang moved this motion as a member of the pro-establishment camp. We agree that she should initiate the procedure. However, at the same time, we also indicated that we're going to vote against the motion. The Liberal Party is taking a milder approach as a party. As for all the incidents relating to the UBWs of the CE and other matters, well, we voted against, and also the impeachment motion, we voted against these motions. We put up the yellow card instead of the red card, and we also considered from a pragmatic point of view. For Pan-Democrats, they constitute more than 1/3. So even if this procedure is initiated, they won't get a 2/3 majority in this council. So the motion will not be passed. And Mr. Albert Chan also made a colorful speech. He said that he was happy to see this motion. he said that if they were relieved of their duties, it would be a chance for them to start a campaign. So probably we should support Dr. Han Chang's motion so that the two members can stage another campaign again. But we're going to vote against it anyway. Mr. Dennis Kwok, I don't really agree with Mr. Ronnie Tong that we should put aside the points of law when we vote. Although he is a barrister, I'm not. The motion to relieve a member of his or her duty is a very solemn process according to the basic law. Now, Mr. Raymond Wong talks about Section 109 of the Criminal Procedure Ordinance. Section 109B 5A states that the suspended sentence under this ordinance is equal to a sentence. But if the sentence of But if it's exactly the same as a sentence of imprisonment, then there is no need to include this provision. The reason why this is written in the law is to state that the nature of a suspended sentence is not the same as a sentence of imprisonment. That is why, as far as the nature of the sentence is concerned, a suspended sentence does not qualify as a sentence according to the provisions in the basic law. So I agree with Mr. Raymond Wong's view, and we have to ask whether we should relieve the member of his duties. If the nature of a suspended sentence is different from the nature of a sentence of imprisonment, then I urge members to read carefully the provisions and understand the difference before moving such a motion. Well, may I remind members once again that I have been very tolerant. I have allowed members to address this issue, but the point today is that Dr. An Chang is asking the House Committee Chairman to move this motion. So if you oppose it, I don't have to do anything. If you vote for it, however, I need to move this motion. So perhaps we can be more concise. Mr. Ng Leung Sing. Now, my viewpoint is that I respect everyone's views, regardless of whether I subscribe to these views or not. I think we need to note this. Even for the election in Taiwan, for those putting up a political grandstanding, well, they get a better chance to win in the election. So whether there is personal gain here, I think we should bear this in mind. Now, in terms of sentencing, I think, yes, the nature of this case may be different from a case involving $1 million. The law says that says imprisonment of 1 month or above. If we are law-abiding legislators, then it's reasonable for us to discuss this issue here. Whether we're of a high standard or not, it's not for me to say here. Now, if we have a debate, then using the same logic, basically, I support this debate because we can then state our positions clearly.
Mr. Leung Yu-chung, the Chairman, you said that there's a question of whether we are in support, or if we are, then you go ahead and do it. There is a question here, even if we support this, will you be doing so on our behalf without any regard to whether this is sensible, legal and lawful, and so on? Well, if it's against the rules of procedure, I won't do it. What about if it is against the law? Well, it is your decision. Will you be doing so on our behalf if it is against the law? Well, first of all, we have to look at the rules of procedure. What we are doing here is if members are supportive, then I would do so on your behalf. I may not necessarily agree with the whole thing, as alluded to by one of the members. If you're not supportive of this idea, I won't do it. So I'm just pointing this out for members that you may be advising a lot of arguments, but this is wholly unnecessary because it's all a question of whether I will be doing so on behalf of the House. Mr. Leung, well, Chairman, I think you have to make it clear. I hope we can bring in the legal advisor here. There are some members who quoted Article 79 of the Basic Law. I think we are quoting it out of context. We are quoting the wording 1 month. Now, we didn't look at the word imprisonment. Now, if the imprisonment doesn't apply to these two members, then I don't think we can seek the endorsement of 2/3 of the members here. This is the precondition. We are trying to activate the mechanism. If the precondition is not predicated on the law or on the rules of procedure, in your opinion, then I don't think we can accept this proposition in the first place. So I like to put this to the legal advisor, that the imprisonment and the suspended sentence, is there any difference there? Would you advise the President to accept this proposal? Well, I call upon Jimmy, but whether it is lawful, the President would sit in judgment. Jimmy. Chairman. Under Article 79(6) of the Basic Law, the proper interpretation, and also 49B of the Rules of Procedure, whether the President can put this on the order paper. Members did express different opinions. I fully respect all the legal arguments advanced by members. 79(6) of the Basic Law, there were two presidents before. The sentences were not the same as the sentences now for these two members. Now, there was this argument about the difference between the imprisonment and suspended sentence under Section 109B1 of the Criminal Procedure Ordinance. Would the two be equivalent? Of course, this has to do with the interpretation of the Basic Law. The Court of Final Appeal interpreted the Basic Law. We are offering our views on that basis. Our view is that after the trial, the court handed down the sentence under the Magistracy Ordinance and also the relevant provision of the Public Order Ordinance. The Criminal Procedure Ordinance gives the court another option to hand down another order regarding the execution of the sentence. So on that score, I feel that the imprisonment should be read as it is written, and also 109B5 5A. Gives rise to a scenario of a member being relieved of his duty. My view is that under 109B5A, it precisely points out that it doesn't apply to this situation because 109B5A applies to those who would lose their qualification, like the driving license and so on, or under the district council ordinance, the relevant provisions, under that circumstance. Because of this prison term, the member would lose the qualification. But for a legal member, he will not automatically lose the qualification, and because there is a mechanism that has to be activated under 49B of the Rules of Procedure. It doesn't happen automatically. It would be for a member to activate this, and it would be for 2/3 of members to endorse the motion before the member would lose the office. Chairman, you said a moment ago that we are here debating on the basis of the facts that we have. Before the meeting, Mr. Raymond Wong made available his submission in response to this particular case. We haven't got time to go over this submission in detail. We'll have a look at this and see whether there are any arguments for which we should offer our further views. With regard to this motion, whether the chairman of the House or any member gives notice for this motion to take place, the President would judge in accordance with the Rules of Procedure to decide whether it should be put on the order paper for debate. Mr. Raymond Wong. Well, you haven't read through my 7-page submission, and Ronnie Tong was very arbitrary in saying that we don't have to look at the law. I'm just merely pointing out the legal perspective. You don't have to waste any time. There may be an appeal. Now, I welcome your attempt to relieve me and Albert Chen of our duties. I would really love this to happen. But here in this council, if you talk about rules of procedures, if you want to talk about the rules and you invoke 79(6) of the Basic Law, I think we have to be progressive. That's precisely why I put together this 7-page submission, not because I want you not to relieve my duties, but rather I want you to bring up all these issues for discussion, because this will constitute a precedent going forward. We have to consider this from this angle. My legal point of view may not be 100% correct. I don't have the ability to say for certain, but I'm just citing this for discussion. A legal advisor told us that he hasn't gone over my submission. Maybe I'm right. Maybe my legal arguments are well-founded, and there will be problems. So, Chairman, I hope that you will think about it. Should we save it till next time? Dr. Priscilla Leung, Chairman. And let me say this. I listened to Mr. Raymond Wong in great detail. I don't think members should bring up family members in their speeches. I never did anything like that myself. It doesn't matter we have different opinions. The fact that we have different opinions doesn't mean that one has a higher standard than the others. I remember last year we did have similar debate, in particular on the question of Mr. Leung Kwok-hong. He was trying to seek an appeal, I did make the point that how can we activate the mechanism under 79.6 when there is an appeal pending. Now, Mr. Jim Pui-chong was really incensed because nobody said anything in regard to his case. And I know that we have some new members here in this term. Now, regarding BL 79.6, the imprisonment sentence, since an appeal is pending, I do have doubts myself. Now, for Mr. Jim Pui-chong's case, there was a decision taken straight away. Now, when we had the discussion, we had to look at the political angle and also the legal angle. 79.6, it is definitely a political decision as to whether we should grant this. I feel that since an appeal is pending, well, I agree that we should defer the decision on this particular case. It's got nothing to do with the suspended sentence. Last time, we said that Mr. Jim Pui-chong's case, I couldn't wait, so we didn't wait. Now, if an appeal is pending, we should object to that. On this basis, I think we should allow the legal advisor to have a little bit more time, maybe in consultation with the counsel outside before taking a decision. Mr. Leung Kwok-hong, Chairman. I remember in a litigation, I asked the judge why I wouldn't be allowed to run for office when an appeal is pending. The government counsel also says similar things. If there is a difference between suspended sentence and imprisonment, if it is a suspended sentence, one doesn't have to go to jail. Now, I cannot say anything on behalf of the administration, but effectively, it was said that there is a difference between imprisonment and a suspended sentence. But can we say this in relation to BL 79.6? I think we have to tread carefully. If there is a court battle, I'm not sure whether the judge would say that he wouldn't care about the legal affairs. But if the judge were to dispute our views, then it would be a really very strange situation. And the president might seek advice from the legal advisor, and we may have activated the mechanism under BL 79.6, and mid-movement we have to stop it in its tract. That would be very strange. I mean, are you counting on the prospect that we don't have the finance to engage in a court battle? I'm terribly unhappy with our legal advisor's views. On what basis did you comment on this 7-page submission? On what basis did you say that the 7-page submission didn't amount to anything at all? Legal advisor, Chairman, a moment ago, it was mentioned whether the LegCo would face an embarrassing situation because there would be an appeal pending, and during the suspended sentence period there would be an increase or decrease in the sentence. This is not what I said. Now, according to the Jim Pui-chong versus LegCo case, the judge also gave a ruling. There were other members mentioning this as well. Now, once the motion has been activated, the procedures will proceed under the ROP. At the present moment, there can be a motion that can be adjourned. Now, whether this is carried or not is the prerogative of members. But procedurally, we can we have the procedure for LegCo to proceed.
主席，
Mr. Chen Hanpen. Chairman, well, some people like to raise questions but just because what's said is not to their liking. Well, Dr. Anne Chang's motion is actually based on the law. The members have breached the law, they caused obstruction, and they, even if they call it an act of justice, so on and so forth, well, a bad deed is a bad deed, and the society will become very dangerous. Well, as for all the sayings about no personal gain, so on and so forth, again, we're going to set a bad example for the children. Well, can one claim that if we murder someone in the name of justice, it's not called murder? Therefore, I support Dr. An Chang's motion. Does any other member wish to speak for the first time? Mr. Tam Yu Chung. I carefully listened to members' comments. In fact, Dr. An Chang is activating the procedure in accordance with the basic law. Now, on suspended sentence, we do have some doubts. When the court handed down the sentence, I was in the lift, and Mr. Ronnie Tong told me that there was no difference between a suspended sentence and an imprisonment sentence. Subsequently, I heard from the President of the Legislative Council that the procedure could be activated, and he actually sought the advice from the legal advisor. And the legal advisor just now also made some comments. So if we look at Article 79.6 of the Basic Law, it clearly states that it's a sentence of imprisonment for 1 month or more. It doesn't say whether it's immediate imprisonment or a suspended sentence. I recall that this is a rather high threshold. It must be imprisonment for 1 month or more before the procedures could be activated, and the member could be relieved of his or her duties by a motion passed by 2/3 of the members present. So some say that we are acting against the law, we are being arbitrary. No, that's not the case. We have been very careful, and I think if we're going to discuss this issue today, whether to activate the procedure, the DAB also respects members. We want to throw this out and ask members whether the procedure should be activated. If members are not supportive, we can reconsider, and every member under the rules of procedure has the right to move this motion to activate the procedure. So we support Dr. An Chang's proposal. Mr. Paul Chair. Well, from the start, I have kept an open mind in whether the member should be relieved of his duties. Now, in relation to the vote of no confidence in the President of LegCo for his cutting the filibuster short, I share the same idea, and that is a platform should be open for discussion. Now, about Chin Pui-chung's case, there was a discussion on the 5th of August 1998, and we discussed how Mr. Chin Pui-chung's case should be dealt with, and Mr. Andrew Wong sought views from the legal advisor, and it was clear that a suspended sentence would not be an obstacle in activating the procedure. Of course, we are not bound by previous incidents, but it serves as reference. Ms. Margaret Ng, Sito Wah, etc., these members also said that we should not look at the nature of the case because we are not passing moral judgments. Once the threshold is reached to safeguard the dignity of the Council, we must do so. As for how members vote, that is up to members at the next stage. Now, point number 3, would appeal be an obstacle? At least to me, it's not. In Chin Pui-chung's case, many members have spoke during the debate, and they shared the same view. Fourthly, the focus of this issue is in relation to the Criminal Procedure Ordinance, Section 109B5A, whether this will pose an obstacle. Again, I think we need to scrutinize it very carefully. My initial idea is that it's not an obstacle. We're running out of time. I hope that Mr. Albert Chan and Mr. Raymond Wong can give us the relevant verdict and judgment. Does any other member wish to speak for the first time? If not, there are 3 members who wish to speak during the second round. 1 minute each. Mr. Dennis Kwok. Chairman, well, just now the legal advisor failed to mention one very important point. If you look at the English version of the Basic Law, Article 79(6), well, sentence is actually in the past tense, is sentenced. That means, according to the Basic Law, the person must have been sentenced. And if we look at the Criminal Procedure Ordinance 109B, it says that the sentence shall not take effect, so on and so forth. That is, the court does have the discretion to suspend the sentence. That's what suspended sentence means. So, the person must have been sentenced in order to meet the requirement under Basic Law. And a suspended sentence is not equivalent to the person being sentenced in that sense. And if a sentence of imprisonment is equivalent to a suspended sentence, there is no need for subsection 5 to appear in under the section. Mr. Leung Yu-chung. Now, Article 79(6) talks about 2 matters. Relief of duties by motion passed by 2/3 of members. Well, there must be a precondition. The precondition is that the person or the member is sentenced to imprisonment for 1 month or more. So even if the motion is passed, if it cannot be executed, then should the chairman accept it? Because there is a precondition here. I'd like the legal advisor to explain more clearly. Just now, chairman also said that only as long as it's in accordance with the ROP, he will put it on the agenda. So my question is whether it is in line with the ROP or the spirit of the law. Legal advisor. Chairman. Well, it's up to the President of the Legislative Council to decide how this motion is to be addressed. Now, as for the first part of the question, that there are 2 conditions for the procedure to be activated, and that means for President to declare the loss of office of the members concerned, then you're correct. If the President makes such announcement, then if a certain facts of the case hasn't occurred, that means, for example, if the member is not sentenced to imprisonment for 1 month or above, then there is a question on the applicability of the motion. Mr. Abraham Sheck, I've carefully listened to members' views from their perspectives, and I support the New People's Party views. I personally will not support it. We should look at it from a political perspective. It doesn't mean that I will agree with the conduct and the ideologies of Mr. Raymond Wong and Albert Chan, but from a political perspective, it's not for me to judge their political conduct. It's up to voters who voted for them to decide what to do. It's different from Chin Pui-chung's case. At that time, Mr. Chin Pui-chung was sentenced to immediate imprisonment instead of a suspended sentence. So about what Dr. Margaret said and Mr. Li Wing had said, I think the two cases are different. One is immediate imprisonment, the other is suspended sentence. The point about immediate imprisonment is that the member can no longer fulfill his responsibilities as a legislator. Whereas for them, they're still here, they're still filibustering. I don't agree with what they do, but it doesn't mean I am opposing this. So we need to be very clear. I think if we are asked to vote on it, I think we need something written. We need to read them very carefully. We need to look at the precedents and see what decisions had been made. Mr. Dennis Kwok was right. It's a point of law. Mr. Ronnie Tong is also right. It's a point of politics as well. The basic law stipulates very clearly what that's Article 79. It has to do with the law and politics as well. That is why 2/3 majority is required. All right, your time is up, Mr. Ma Fung Kwok. Well, originally I didn't intend to speak. I don't want to waste members' time. I think the two topics for discussion today are different. Well, I need to look after the 4 subsectors. I was against the first one because I also want a debate slot. So I was against the first one. As for the second one, it's a matter of whether we act in accordance with the law. Now, the only point in question is whether a suspended sentence is in any way in conflict with Section 109B, and I've heard from the legal advisor and I accept his views. So this procedure should be activated regardless of what offense being committed by whatever member. As for whether who should activate the procedure, I think this is a matter, it's a political issue. As for whether the threshold of activating the procedure is met, well, I subscribe to legal advisor's views. However, I also think that we should consider it more carefully. There is no urgency in this matter, and I agree that we can defer the discussion. This is clear. As for how we vote on it, we can make our political decisions later on. Mr. Christopher Chung. Well, one should always bear one's consequences. Well, they saw it coming anyway. Other members try to argue based on the legal text. Well, but everything is clearly written. They have been sentenced for 1 month or more, and therefore the procedure should be activated. When we talk about sentencing, it's a matter of how the sentence is to be executed. In some places, well, one can pay a fine of $100,000 in lieu of a sentence. So does that mean the procedure cannot be activated? The arguments doesn't hold water. The magistrate sentenced them to 5 weeks or 6 weeks, and that's it. As whether they should be relieved of their duties, I think it's a political issue. If there aren't enough votes, all right, the motion won't be carried. If there are enough votes, all right, so we should step down. You talked about other pieces of legislation and other circumstances to try to confuse us. Well, even the members involved are not very concerned about the consequence. I don't know why other members are trying to confuse us. The sentence is one of more than 1 month. That's clear from the magistrate. And as for whether it's a suspended sentence or not, basically doesn't affect what's written in the basic law.
James Stowe. Chairman, I think we have to tread carefully. I would respect the legal advisor's views. As a lawyer myself, I tend to concur with him. I think we have to be safe than sorry. Mr. Raymond Wong has advanced some elaborate arguments. I get the feeling that he has some legal backing in putting together this submission. If the President of the Council did say that even for suspended sentence we can activate the mechanism, and the legal advisor also advanced his argument. I think for to play safe, we should read the detailed legal analysis from the legal advisor. If members would like to give their input, so it should be fine. I would be happy to read it. But I believe that even for suspended sentence, we can activate the mechanism. But we cannot support this motion. I think at the end of the day, we should let all the members have a detailed look at the whole situation before coming to any final decision. Mr. Leung Kwok-hong, 1 minute, please. Chairman, this is a legal matter. The President and the legal advisor have not handed down any ruling. I think what you said amounts to hot air. If you respect the Council, you should give us something in writing, in black and white. I understand that there was a political verdict, but we are debating whether we should move this motion. We have to be careful. Mr. Chen Han-pan said that if we have committed the offense, we should be subject to the proceeding. Now, there are so many people who murdered unlawfully, like Tojo in Japan, like the Communist Party overthrowing the KMT, and so on. Mr. Porche, I think Mr. James To has confused the matter. Whether we should activate the mechanism, we should go by Ms. Margaret Ng's argument. We should look at the facts of this sentence. Mr. Daniel Kwok mentioned the past tense of the word sentence. I think he has got it wrong. That is a passive voice, not a past tense. Sentence has to be in the past tense because it is a passive voice, like convicted. Also, the President has to take a decision on the basis of facts. That, like the old chamber, there is this goddess on the roof. She's blindfolded. We should not look at the political consequence. We should look at the facts. Does any other member wish to speak? Mr. Rimshek, 1 minute, please. Well, I fully understand that, Paul. I'm no lawyer myself, but I think I have looked at the ins and outs of a particular case. Maybe Paul liked Margaret Ng's argument, and she's not here today. You don't have to adduce her argument. I never listened to what she had to say. I think we have to look at the ins and outs of a particular case. Now, I'm not blind. Why do you have to blindfold me? We're looking at the facts. We have to look at this political issue from a legal point of view. You cannot say that we ignore the matter, we don't ask any questions. That's simply not on. Mr. Raymond Wong, 2 minutes. And then Mr. Albert Chen, if he's here, 2 minutes also. And after Dr. Yan Zhang, I'll put it to the vote. Mr. Raymond Wong. Chairman, thank you. I think this debate is very beneficial and constructive. This is a new case for LegCo to activate this mechanism to relieve members' duties under BL 76. We did this twice, and this is the third time. The natures are so different. I must reiterate that I'm not jumping to my own defense. I agree with Mr. Zhong Shu-kan, Mr. Christopher Zhong, that if we can't stand the heat, we have to get out of the kitchen. Now, if you have advanced new arguments, fine. I mean, this is the whole spirit of the council. Jimmy can engage us in a debate, or he can engage Dennis Quokka for a debate. My argument is very simple. This will give rise to a legal debate. It's not just for myself. There may be other members who may be sentenced to suspend the sentence. I hope that we should think about this from this angle. I never try to defend myself. We can never vote if this motion does go ahead. It's up to members to decide. It is a political decision, or whatever decision it is. But here in this House committee, if we have to activate this procedure, we have to leave it to the chairman. I don't really want the chairman to do anything which is unlawful, or there may be a legal battle over this going forward. If the president and the legal advisor, after careful scrutiny, finds that there are no problems, then they have to shoulder the responsibility, and we can activate the whole procedures. As simple as that. So I hope that if members are in agreement with me, then we can leave it till next time. We can have another debate at the next House committee. Thanks very much for your concern, Mr. Raymond Wong. Dr. N. Chang, Chairman, is all very clear. Previously, we did activate this mechanism on 2 occasions. On one occasion, we succeeded. The other one, we went to the council meeting direct. Now, the council, the senior council party, has made it very clear. Now, Ms. Margaret Ng said that if there is a member who is sentenced to 1 month imprisonment, there should be a motion moved to relieve him or her of the duties to safeguard the integrity of the council. Chairman, the previous House Committee Chairman, Dr. Leung Chi-hong, made it clear that if a councillor has been convicted of a criminal offence, and if he continues to be a member of the council, how can we be accountable to the general public? Where will this leave our integrity and dignity? I never thought about this motion before, but since the DAB wants someone to move this, then I feel that I should do it if nobody else would like to do it. I think we have to be clear about the legal point of view. Now, I mean, it may sound bad to kick someone out of the council, but we are acting in accordance with the law. Some may argue for this, some may argue against this. Aren't we embracing the core values of Hong Kong? Aren't we respecting the judiciary in Hong Kong? The judge has handed down the ruling. It doesn't matter, Chairman. I respect the views of everyone here. I would suggest that our legal advisor look at all the doubts. Next Friday, we come back for more of the same. Maybe we don't have to have any debate, and then we can put it to the vote next Friday. And the chairman might call upon the legal advisor to clarify all the matters. All right, this is how I take this forward. It's up to you whether you like to put it to the vote. You can withdraw the motion. I won't ask you to withdraw the motion. And if you do so, then next week you have to move this again in accordance with all the procedures. What you are supposed to do now is a question of whether I should do so on your behalf. It's not a question of whether we should do it or not. Even if we vote in favor of me, in my capacity as chairman of the House Committee, doing this on members' behalf, then it would be for the President to deem it lawful before this will be put on the agenda. So there is no question of this being taken forward if it is unlawful. So it's up to you whether you like to put it to the vote, whether you like to proceed. If you don't withdraw, then we have to put it to the vote. Otherwise, we can put it to the vote. You have to give notice again if you withdraw the motion. Dr. Zhang. Chairman, I can take back the motion today, but I urge the legal advisor to clarify all the doubts in the minds of everyone so that they would die happy. I've got nothing else. Meeting adjourned.